Well, thank you very much, Professor Peters. I'd like really to thank you and to thank the Institute for this very, very kind invitation. When I met Professor Peters in Toulouse a few months ago, I had presented this paper at a workshop in Rome a few weeks earlier, and I was utterly destroyed. So I shelved the paper, and when I talked to Professor Peters about it, she told me, but why don't you come here to Heidelberg to present it again so that you can decide whether to throw it in the bin definitely or not. So thanks very much, Anna. This is a real honor for me to be here. So first, I'd like to start with some kind of a caveat or caveat emptor, the emptorers being you. I am not an international lawyer by any definition of that term. I have been teaching international law for almost 10 years now, and I enjoy it tremendously, but my main fields are constitutional law on the one hand, especially comparative constitutional law, and legal philosophy. And my approach here and today to international law is that of a legal philosopher, not that of an international lawyer. So that's why I apologize in advance for the queer sounding or trivial sounding quality of my talk. I'd like to start off with a few quotes in order to understand the state of the discussion. So the father of Ius Cogens, so to say, Alfred Verdross, in his famous paper on Ius Cogens and Ius Dispositivum in 1966, traces back the problematic of Ius Cogens to the natural law school of international law, which starts from the idea of a necessary law, which all states are obliged to observe. And ever since the Vienna Convention entered into force, and even before it entered into force, ever since it was signed, international legal theorists have been keen on pointing out what Ius Cogens owes to anti-positivism, or at least to natural law theories and theorizing. Classical article again. Unfortunately, sorry, it's only in French, but by Charles de Visscher in 1971, argues that when we're talking about Ius Cogens, positive law is not enough. We have to go from formal sources to what he calls the moral foundation of the law. That's what's in the middle of the quote here. I'm not going to read it all in French. I'm going to spare you that ordeal. So, and this aspect of Ius Cogens has been stressed again and again by many authors to rejoice or to lament it. For instance, Prosper Weil in 1983, in his paper on relative normativity in international law, writes that Ius Cogens, along with other phenomena such as soft law, this relativization of international legal normativity jeopardizes positivism, that is the ability to distinguish between the lex lata, the law as it is, and the lex ferenda, the law as it should be. And in more recent times, we find again and again, and those are only 3 examples, but they are to be found in abundance. You find again and again this leitmotif that positivism cannot cope with Ius Cogens. Cançado Trindade, in his separate opinion on the Castro prison case, wrote that underlying the concept of Ius Cogens is the natural law theory, which leads to peremptory regulations based on the affirmation and enshrinement of ethical values that seek to benefit humanity as a whole. And we find this same idea expressed by very diverse authors coming from very diverse backgrounds. So what is the problem? what those not so random, but a bit random, and nevertheless quotes show is that according to many writers, Ius Cogens poses a threat to a positivistic conception of the international legal system. Ius Cogens, it has been said, it is infused with moral values and cannot be apprehended in a positivistic way. And what I'm trying to show in this paper, I'm not sure if I succeed in doing so, but what I'm trying to show is to show that at least according to the conception of legal positivism that is no commonplace in mainstream legal philosophy, this threat has been exaggerated. That actually there is a conception of Ius Cogens, an interpretation of Ius Cogens that is perfectly compatible with legal positivism. So let me be clear about what this paper aims and does not aim to show. I will aim to show that if you hold a positivistic conception of law, Ius Cogens does not pose an existential threat to your theoretical framework. But however, I will not try to show that positivism is good. I will not try to show that legal positivism is the right approach to law in general or international law in particular. And if you think that legal positivism is wrong, and you're perfectly entitled to think that way, I will do nothing to convince you otherwise. Incidentally, I will not try either to show that Ius Cogens is real, or Ius Cogens as it is being hyped today, especially in the light of the fifth report of the International Law Commission, exists. I think it exists, but if I'm talking about a fiction, it makes no difference to the point I'm trying to make. So I will proceed according to three main steps. First, I'm going to try to give a workable definition of positivism that will prove to be both thin and broad. But I think that this definition that I have not invented, that you find in the literature, is both the most common and the smallest common denominator definition of legal positivism. Then I'm going to try to show that under a received interpretation, which is interpretation of the International Law Commission and its special rapporteur himself, Ius Cogens has to be interpreted through and through as positive law. And I'm going to raise one additional worry to conclude about one aspect of Ius Cogens that seems to have eluded not all, but some scholars, which is an aspect that bears on its modifiability. So when we talk about Ius Cogens, we usually talk about derogability or non-derogability as the specific function of Ius Cogens. But I'm going to try to show that there is a danger that Ius Cogens can pose to positivism, which is that if we take Ius Cogens to its logical conclusion, well, it serves as some kind of a ratchet effect. And the question whether as a logical matter, not as a practical matter, but as a logical matter, Ius Cogens norms can be modified. If it makes sense to modify them, well, this question needs to be raised. And if the answer is no, this is a real threat, in my opinion, to positivism such as I will define it. So first part, positivism, what? So what I'm going to try to do first is to distinguish positivism among various possible definitions. So I will first distinguish positivism from what it is not, and then I'm going to try to define it. The pars construens will follow the pars discerens. So first, I will try to show that as quickly as possible that positivism shouldn't be confused with voluntarism, with what can be called ideological positivism, normative positivism, what I call Gesetzpositivismus, maybe because I'm in Germany, and positivism as a methodology, as an epistemological theory, which it can be, but which it won't be under my definition. So first, but this has already been debunked by many authors today. There is most notably recently a paper by Devika Hovel in Current Legal Problems that even starts by saying that, well, the premise that positivism equals voluntarism has not been true in many years. So in an international context, yes, positivism is very often equated with voluntarism, with the idea that all law depends directly or indirectly on the will or the consent of the states. And of course, if you're a voluntarist, then Ius Cogens is somewhat of a problem for you, because obviously the whole point about Ius Cogens is that it creates obligation that states will not have consented to. I will deal with some of these aspects later when we will be talking about the persistent objector issue a bit later on. So yes, if you define stipulatively, but if you define positivism as voluntarism, yes, Ius Cogens will be a problem for you. But if you try to broaden your scope a little bit, you will notice that mainstream legal positivism today in the mainstream legal philosophy is not voluntaristic or necessarily voluntaristic. And historically, voluntarism as a legal philosophical option, theoretical option, is compatible with a natural outlook, the main example being Samuel von Pufendorf. So I will set aside voluntarism altogether, and I will not be dealing with any kind of objection that a voluntarist scholar would have against Ius Cogens. Legal positivism is not Gesetzpositivismus, that is an ideology of positive law. It does not hold that law is necessarily laid down by an authoritative lawgiver, for instance, the legislature, and it certainly does not hold that subjects should obey statutes, legislation, or law in general. Positivism, such as I understand it, so to say, is not a legalist ideology. The idea that law should be obeyed and that there should be, for instance, a strict distinction between legal creation and legal application. There are some trends, even nowadays, the authors I mentioned in the bottom of the slide, that do claim that positivism is best understood as an ideological or as a normative theory, but that's not the definition that I will expound here. And third, that is the most difficult distinction because it is the one that can be, I think, disputed the most easily, which is that positivism shouldn't be understood as a methodological thesis. The way I define it, positivism, legal positivism, is not a theory of legal science, which may sound a bit strange because on the continent, in the Kelsenian, but also in the Scandinavian or in the Italian tradition, legal positivism has been defined as a theory of legal science, much more as a theory of what we could call the nature of law. Legal positivism is the theory, Kelsen being a case in point, according to which legal science ought to be morally neutral or value-free, that you should be able to make legal statements, scientific statements about the law without any kind of moral evaluation. And international lawyers have heavily relied on this conception of legal positivism. However important this methodological conception of positivism is on the continent, it is not universally shared. And in the Anglo-American tradition in legal philosophy, this emphasis on legal science is almost inexistent. I mean, you will not find in Hart, Raz, Dworkin, or any author in the Anglo-American canon any kind of emphasis on what legal scholars, qua scientists, should do. So when I talk about positivism, I refer to a substantive conception of law, a conception of what law is, not a conception of legal knowledge or legal science. And on the one hand, it's not a problem because the latter presupposes the former. The methodological presupposes the substantive. Legal science can be value neutral if and only if there is a distinction that can be made in the first place between the law as it is and the law as it ought to be, which we shall soon see is the substance of legal positivism. So if positivism is none of the above, what is positivism? So let's try to give first a thin definition of positivism, a smallest common denominator definition of positivism, and then I'm going to try to show that it should be understood in a broad way so as to cover both the domestic and the international context. So this smallest common denominator definition of positivism was, I think, offered by John Gardner in a 2001 article, Legal Positivism's 5.5 Myth. According to Gardner, and I think he's basically right, legal positivism is mainly a thesis about validity. And as such, it is a very limited thesis that doesn't cover all the ground that legal philosophy is supposed to cover. I mean, legal positivists can disagree on many things, but what they will agree on will be this. The idea that in any legal system, I quote, whether a given norm is legally valid, and hence whether it forms part of the law of that system, depends on its sources, not its merits, moral or otherwise. And I put the parenthesis aside. So this is a very thin definition that breaks down into two main components. First, the social sources thesis and the separation thesis second. The social sources thesis that has been expanded notably by Raz in The Authority of Law and related writings, argues that the validity of legal norms depends on social facts, namely sources. Whether a legal norm is legal, whether it belongs to the legal system, depends on whether it satisfies some criteria of validity that are picked out by the system's rule of recognition. So basically, the system of recognition, the rule of recognition, picks out certain facts. For instance, the fact that, I don't know, in a hall, you have members of parliament that raise their hands and say, I vote, and then you have the president of the republic or the Bundespräsident that enacts the law, signs it into law. This set of facts are enough to constitute a source of law, and those are social facts. In order to ascertain that the law that if you are punished, if you commit murder, then you ought to be punished, is law, you just need to show that it is traceable back to a certain set of facts that are the sources of law. And the second leg of legal positivism is the separation thesis, that the validity of legal norms does not depend on their moral merit, on their merit, moral or otherwise. It's not only a thin definition, but as I said, it's a broad definition. It's intended to apply to domestic legal orders, but it also covers, I think, the international legal system or systems, so to say. So it provides a low threshold for the criteria of legal validity. Criteria of legal validity are social facts, but human communities are perfectly fine to make some set of facts sources of law and some others not sources of law. For instance, it's perfectly fine under this definition that custom is a source of law because custom is at heart a social fact or set of social facts. It is a non-statist conception of law that the law not necessarily stems from the will of state or from state activity. You could have a description of quasi-legal systems, such as, I don't know, Lex Sportiva, FIFA, everything you can imagine, that could still fit those criteria. And it can accommodate decentralized legal systems. It does not presuppose that there is only one source of law and that there needs to be only one lawgiver. So contrary to scholars who argue that a positivistic outlook on international law needs to be modeled onto the specificities of the international legal system, I will proceed under the assumption that the definition is the same across all legal or even quasi-legal systems. It doesn't mean that those systems are the same. They are different in many respects. For instance, in international law poses to some extent a problem because international law is a particularly complex system of sources where custom and treaties are in a complex relation. They interplay to some extent. And in international law, the distinction between the lex lata and the lex ferenda is not always easy to make. If you take, for instance, I don't know, the statutes of the draft conclusions of the International Law Commission, what is that? Is it lex lata? Is it lex ferenda? We don't know. And the same way, if you have custom, at what point does the violation of the rule become the crystallization of a new customary rule? You can't pinpoint the exact time when the old law is abandoned and the new law is abandoned. For instance, in the 2012 case, Germany versus Italy, the International Court of Justice said, well, look, state of the law as it is this, but you can change it. So the Italian Constitutional Court, as is well known, said, well, I'm going to change it. But is the attitude of the Italian Constitutional Court and of the Italian state a violation of customary law or a first step into changing it? We don't know. But that does not mean that this positivistic conception is not suitable. It just means that the rule of recognition is open textured, which it is to some extent in any kind of legal system. But international law is a legal system where the rule of recognition is to a larger extent open textured and indeterminate. So now on to my second part, which is the main course, so to say, Ius Cogens as positive law. So I'm going to be quite quick on the first subpart, so to say, where I try to show that obviously the question now is different as it was in 1969 or in 1937 when Verdross wrote his Forbidden Treaties paper. As I tried to show in this first subpart, Ius Cogens has evolved from a treaty law regime, so to say, a condition of validity of treaties to an element of the international public order, but this is very well known, and I don't think that I have anything interesting to bring to that debate, so I will skip directly to my second moment. So, as a mere set of peremptory norms, Ius Cogens has no natural law flavor per se. The idea that there are some norms that are imperative and some others that are suppletive, use dispositivum. I mean, it's a fixture of any contract law in any country, including mine, at least in the civil law tradition. I mean, first year, second year law students in my country learn about this idea that some laws can be displaced and some can't by contract. So for instance, if we were to draw an analogy between domestic legal systems and the international legal system, I would certainly argue that the law that prevents concluding treaties under duress, namely Articles 50, 51 and 52 of the Vienna Convention, are Ius Cogens. Since those norms are certainly Ius Cogens in many domestic legal systems. However, this is not the way we interpret Ius Cogens nowadays. I take an example, I think it's also well known, of something that seems very weird today. The idea that the equidistance principle, when you determine the rights on the continental shelf, the equidistance principle is Ius Cogens. Would the International Commission think that the equidistance principle is Ius Cogens? Well, Judge Tanaka, in his separate opinion under the North Continental Shelf case, said that it was.
Which principle?
The principle of equidistance. So obviously it's not Ius Cogens. So why did those people understand those rules as Ius Cogens, and why do we not? Because now Ius Cogens is understood as a set of moral norms, norms that have a higher moral weight than ordinary norms, so to say. And that is obviously something that Alfred Verdross, who was a natural lawyer, the father of Ius Cogens, clearly saw, even as he was talking about treaties and not international behavior in general. He was saying that basically Ius Cogens that was prohibiting some treaties to be concluded was a moral set of norms, that forbidden treaties were immoral treaties. And nowadays, obviously, Ius Cogens mainly refers to immoral behavior of states rather than just immoral treaties. And obviously, this view has been taken up by the International Law Commission in draft conclusion 2 of the 5th report that was adopted last September. Peremptory norms reflect and protect fundamental values of the international community. So although this is not the approach taken by the conclusion and its special reporter, draft conclusion 2 can easily be reconstructed in an anti-positivistic way. So if I were to put forward an anti-positivistic conception of Ius Cogens, it would be the following, and that's what I intend to refute. Ius Cogens is an autonomous source of law. It is a separate body of rules. As such, it is not made up only of social facts, such as, for instance, custom, but it is also made up of moral facts. You cannot ascertain the status of Ius Cogens norms qua Ius Cogens norms without indulging in moral evaluation. Then Ius Cogens norms can be only identified as such via the recourse to moral evaluation, to moral values, to fundamental moral values. And the validity of Ius Cogens norms depends on their moral merit and not on their social sources, quod erat demonstrandum. So in order to show that this reasoning is flawed, one just needs to refute some of its premises, which is, to my mind, exactly what the International Law Commission does in draft conclusions 3 to 9, sorry, when it puts forward what I call the two-step process. The bottom line is that Ius Cogens is not an autonomous source of law. So if you do not grant that premise, the rest of the reasoning fails. So as you know, the draft conclusion 3 of the report uses roughly the same formulation as Article 53 of the Vienna Convention. Peremptory norm is norm of general international law, from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. So And draft conclusions 4 to 9 will use a two-step process to identify Ius Cogens norms. First, you need to identify a norm of general intentional law. Well, custom will be the clearest basis, but due to the dynamic interplay between custom and treaties that I mentioned a bit earlier, the norm could also be a treaty norm, or at least comprised of some treaty provision. And second, only in a second time, you identify the acceptance and recognition by the international community of the states of the Ius Cogens character of the norm. So this two-step process refers to a logical and not merely chronological distinction. In practice, the distinction between the two steps can be muddied a bit, can be a bit difficult to disintricate. For instance, the acceptance and recognition as Ius Cogens can be part of the opinio juris that gives birth to the customary norm itself. However, those two steps must be logically distinguished. They are two different logical steps. So as a result, Ius Cogens is not an autonomous source of law. Ius Cogens norms are otherwise valid norms, customary norms, but also general principle of law, treaty provisions that can be traced back to a set of social facts. Then their normativity is enhanced insofar as they are relatively entrenched and non-derogable, and more broadly, indefeasible. The non-derogability is often understood to refer only to the impossibility of non-derogability by treaty, no contrary treaty provision, but nowadays it means that no exception can be granted to a Ius Cogens rule. So the non-derogability is only part of the rule, indefeasibility. It bears emphasizing that acceptance and recognition are also a social fact or a set of social facts. But as such, as it has no bearing on the validity of the norm, on its membership within the international legal system. Whether a Ius Cogens norm belongs on or does not belong to the international legal system is wholly dependent on whether it's traceable to a social source. So basically, you have the following two-step process. You have a set of social facts, practice opinio juris, then you have a norm, which is valid, and then you have the acceptance and recognition of the norm, which elevates it, so to say, to the status of Ius Cogens. And what does acceptance and recognition do? It triggers the applicability of a set of meta-norms, of norms about norms, which Linderfeld calls second-order Ius Cogens norms, the non-derogability, the non-modifiability, etc., etc. So basically, the basic conception is this: acceptance and recognition triggers a set of meta-norms, which protects Ius Cogens norms from derogation and modification. So, in a nutshell, Ius Cogens is perfectly compatible with the positivistic conception of law. It does not affect the fact that the identification of a norm as valid international law depends solely on social facts. That does not make fundamental values irrelevant to the explication or explanation of what Ius Cogens is. To the contrary, values explain why norms have such and such content. You cannot explain why the prohibition of murder is a more important norm than the prohibition of jaywalking if you have not recourse to fundamental moral values. So values have a causal function. They explain why norms are what they are, but they do not have a conceptual or logical function in explaining the norm's validity. And I have a very long quote by Adil Haq on this. I will spare you the quote, but I refer you to his very enlightening paper that he uploaded on SSRN recently on peremptory norms and fundamental values, which I highly recommend. So now on to part 3, because up to now, what I said is very nice. It's I can go back to my dogmatic slumber. Positivism is fine. No existential threat. Well, not so fast. The main problem is the following. A Ius Cogens norm can only be modified or repealed, which I will take as the same. And I have an argument of authority from a very interesting paper by Payande. A norm can only be modified, Ius Cogens norms can only be modified by another Ius Cogens norm. But if you agree that the two-step process is the right way to understand Ius Cogens norm creation, then modification is impossible. Since according to the two-step model, this modified Ius Cogens norm must be a legal norm in the first place, which it can't be. Because if you have a new norm which conflicts, at least pro tanto, with the norm it aims to modify, and that norm that it aims to modify is a Ius Cogens norm, well, this new norm cannot be valid and then cannot be elevated to the status of Ius Cogens. Therefore, Ius Cogens acts as a ratchet effect. Once a Ius Cogens norm exists, it cannot be modified as a matter of logic. And why is that a problem? Because positivism at heart presupposes that law is a human enterprise, so that no legal norms are beyond human reach. The non-modifiability rather than the non-derogability feature of Ius Cogens is a threat to that specific consequence of legal positivism. And let me try to explain what I have in mind by making a comparison with the way entrenched rules work in constitutional systems. So let me take an example, Article 79, paragraph 3 of, for instance, of the German basic law. But let's say that, for instance, N1 is the protection of human dignity, N2 is the democratie principle, and N3 is the federal organization of the state. It's a simplification. So you basically have a meta-norm, that is the Ewigkeitsklausel, that says that those three norms or set of norms cannot be modified. They cannot be modified or abridged from the Constitution. So basically, if you're a positivist, you will not be satisfied with this idea that norms are beyond the reach of even the will of the German people, so to say. So what you will do, and that, for instance, that was what French constitutional professor Georges Vedel argued for in a series of articles in the 90s, that the meta-norm itself is not protected, right? So you can modify it via ordinary amendment. So you can modify Article 79, paragraph 3 of the Grundgesetz because it doesn't protect itself. So you modify, for instance, if you want to be over with N2, sorry, you just modify the Ewigkeitsklausel, the meta-norm, you remove N2 from the set of protected norms, and then, well, you modify N2 by, or replace it by N3. So that's the way, of course, this is disputed, and it is quite disputed by many constitutional law professors that would argue that this is an abuse of procedure, that this is not acceptable, that is a betrayal of the constitutional foundation, that it is a constitutional dismemberment. Professor Albert and Professor Rosenay have been very vocal to that effect, and I respect their argument. But if I'm, let's say that this model is at least plausible. That's all I need to have. So now, how does it work about Ius Cogens? In Ius Cogens, you have a meta-norm that says, for instance, that Ius Cogens norm 1, JCN1, shan't be modified except by another Ius Cogens norm. So you want to modify N1 by N2, JCN1 by JCN2, then you need, according to the two-step process, have N2 in the first place, that this norm exists as a treaty norm or more obviously as a customary norm. But since N2 conflicts, at least pro tanto, to the extent that it wants to modify it, the norm that it aims to modify, then it can't exist because according to Article 53 of the Vienna Convention, it is null and void. So it can't exist. So if it doesn't exist, it can't be elevated to the status of Ius Cogens, and then modification is impossible. So contrary, the upshot is contrary to unconstitutional constitutional amendments, it is impossible to first strip the norm of its protected Ius Cogens status in order to modify it afterwards. First, the modified norm has to exist, first step, in order to gain protected status, second step. But the first step is a non-starter since the new norm conflicts with the earlier one, which it can't, and therefore is null and void. So there are different solutions that are possible to this conundrum. The easiest solution is to say that it's not a two-step process, it's a one-step process, that whatever goes for the creation of Ius Cogens, the modification of Ius Cogens will be only one step. The norm will be at the outset, so to say, a Ius Cogens norm, which for me is complicated for many reasons. First, because the two-step process is not a chronological, it's a logical distinction. And second, because you need to have a theory, and the onus is on you to have this theory to show why creation on the one hand and modification on the other one hand should be different processes. The second idea is second solution has been put forward by Linda Falk in his paper on Ius Cogens and positivism in 2013 and in his more recent book as well, which means to say that it's a bit like the Ewigkeitsklauseln I was talking about a bit earlier. Metanorms are not themselves Ius Cogens, they are ordinary customary law. So they can be modified as any kind of customary law. So the move that the abuse of procedure that I explained a bit earlier could be made also cogent here. So if a state S persistently objects to elevation of a norm to Ius Cogens norm, then this status is not opposable to state S. And something is wrong here. And I think that we can all smell the rat. And Linda Falk himself smells the rat and tries to catch it in an articulate way. But I'm not very convinced because he suggests the following alternative. So he has this theory that metanorms, second order Ius Cogens norms are ordinary customary norms. They can be modified. Quite easily by ordinary customary law. So he says, well, we have the alternative. Either we say that the persistent objection theory always holds. So we have the problem we just see that a state could subtract himself from the application of a Ius Cogens norm just because it persistently objected to its formation. Or we could say that the persistent objection rule never has no effect whatsoever. But I think there is a more obvious possibility to this conundrum is just we just reject Linda Falk's solution. Metanorms are not, sorry for the, I mean, I drafted these slides very quickly, so sorry for the orthographic mishaps here and now. Metanorms are not customary norms. They are just logical requirements that need to obtain if and only if one admits that Ius Cogens exists. You cannot hold the idea that Ius Cogens norms exist and not take those metanorms as logical requirements. So I have a third solution that, sorry, I'm a bit long. It's going to be over soon. Don't worry. A last solution that I propose, which is to distinguish membership from applicability. So basically, when we say that a norm is valid, we can mean many kinds of different things. It is a very ambiguous concept, as you know, the concept of validity. But mainly, the idea is the following: that a norm exists when it satisfies some conditions established by the rule of recognition. It satisfies some criteria of validity that are just social facts, the existence of social facts to which the norm can be traced. So basically, if a law is enacted by Parliament and the President of the Republic in France, it is law. But this law could be wholly unconstitutional. But it could be wholly contrary or conflicting with higher ranking norms, superior norms, such as the constitutional norms, but it still exists. It is still valid in the sense that it belongs to the legal system. Judges can use them, administrative bodies can use them until, and only until, it is repealed. That is the Kelsenian motto, no nullity, only annullability. So for me, this distinction between membership on the one hand and applicability on the other hand is the key to solving the problem here, because applicability means that the law ought to be applied either by a judge or in a decentralized legal system by the first self-appliers, which are the states themselves. So you can have a mismatch between membership and applicability in many kinds of situations. Think of a law that has been passed, but which is due to enter into force only 6 months from now. It is valid, it belongs to the legal system for the simple reason that you can modify it, you can repeal it, you can do all sorts of normative operations which you can't do on laws that do not belong to your legal system. But it's not applicable. If a judge applies it before it's entering into force, its ruling will be quashed by a superior court. And contrary-wise, when in private international law settings, a judge applies a French judge applies a German law, well, this law does not belong to the legal system. It's not valid in the French legal system because no French authority can repeal or modify that law, but it's still applicable since a judge has the power and sometimes the obligation to apply it. So basically, the solution to a normative conflict is not invalidity, it's not the suppression or the disappearance of the norm, it is its disapplication. So when you have a normative conflict between two norms, it doesn't mean that one of the norms doesn't exist, it's just that it can't be applied. So if N2 conflicts with Ius Cogens norm N1 and aims to derogate from it, it will not be applicable ex tunc, but it will still belong to the legal system until it has itself been repealed or modified. And such, it does not prevent the two-step process from taking place. So basically, you have this two-step process. You have a norm that is neutralized, so to say, that is not applicable, such as in the cases of vacatio legis that I mentioned earlier. And whenever the second step occurs, then it has the function, the status of a Ius Cogens norm, and it can quite easily modify the first one. So, few words to conclude now. What I've tried to show in the following, was the following. Ius Cogens does not contradict a positivistic conception of international law. Ius Cogens is not an autonomous source of law, but a specific status conferred onto already existing valid norms by specific metanorms. That is the two-step process that I think is the one adopted by the International Law Commission. And Ius Cogens norms are not a brooding omnipresence in the sky. They are human-made laws that can be modified as such. Now, again, what I have not tried to show is legal positivism is a sound and apt view of the nature of law. I think it is, but if you disagree with me, you're perfectly free to do so. And Ius Cogens norms exist. You can still have a very skeptical Gilbert Guillaume-like view of Ius Cogens, if you like, that it doesn't exist. It's just some kinds of juristic hubris by lawyers who think that they can give the world some kind of moral legislation. But even if you don't think that Ius Cogens exists, I think that my points still hold. Thank you very much for your patience and attention.